Welcome, everybody. We're doing our Zoom UOCA monthly meeting. This month we have Paul Roberts. He's going to present to us since we weren't able to do our conference last year. He's going to give us some legal information. And Paul, would you like to go ahead and take it over?
Well, sure. Let me just start sharing my screen here and can get started. I thought you were going to have some business or something before me.
So far, I've been doing any of that stuff at the end.
Okay.
But if that would help you while you're loading up, I can give a little member business.
I think I got it.
Okay.
Okay. Well, good morning, everyone. It's good to see you. It was kind of sad to miss the conference last year. I'm sure you were all sad too. It's something I look forward to. But I've done a couple of Zoom, either in part of Zoom trainings as a presenter or as a participant, and I've found that it's really hard to get people to participate. So for a couple reasons. First, I can't see any of your faces, so I don't know if you're like raising your hand. If you want to ask a question or comment or something, please just interrupt. I won't consider it rude. I won't be annoyed or anything like that. But I won't be able to see like the raised hand feature or anything. Just jump right in. So Christina asked that I talk about the Sixth Amendment a little bit. So here we go. I'm going to try and cover as much information as I can as fast as I can. And it's not forwarding. Okay, here we go. Okay, so what is the Sixth Amendment? It's something that applies for all of us who live in the United States. It gives us certain protections. And there's quite a few of them actually packed into there. Speedy public trial before an impartial jury, the right to confront witnesses, the right to know the charges and the evidence against you, and then also the right to have an attorney to help you. Why do we have these protections? Why do we have it? When I think of the trials and things, I really enjoyed the book To Kill a Mockingbird, and you have Atticus Finch at one point explaining to Scout, how do you understand and start empathy for people? He says, you never really understand a person until you consider things from his point of view, until you climb in his skin and walk around in it. The Sixth Amendment is there to protect all of us, because imagine if you were wrongfully accused of a crime, you would want to have all those protections. And so we make sure that we afford that right to everyone who might be accused of a crime, whether rightfully or wrongfully. And of course, in To Kill a Mockingbird, if you haven't read it by now, I'm going to spoil it for you. It doesn't work out well for Tom. The system fails him. He's very clearly innocent, but the way things go in that particular community, he's convicted of the offense. Now, the plain text of the amendment very clearly only applies to criminal prosecutions. So if any of you use administrative proceedings for most of your code enforcement work, these things don't apply. Now, people will think they do. They'll think that they've got the right to a speedy trial. They'll want a jury trial. All those things. Those rights just don't apply to that. There are certain due process rights that apply to civil proceedings, and that would include basic confrontation, things like that. But you can rely on a lot more in a non-criminal proceeding than you can in criminal ones. But we're going to focus mostly on the Sixth Amendment, which applies to criminal prosecutions. So why do we need speedy trials? Many times, especially with more serious offenses, a person is taken into custody, they're arrested, and then when charging documents have been filed, they're held in custody until the trial occurs. So that can take months, and in complicated cases, well over a year as things stretch on. That person is sitting in jail. They're essentially being punished without having been convicted, right? Because they aren't able to go about their business. They can't work. They can't support their families. And a lot of times at the end of a trial, after they're convicted, they're given credit for that time that they have served. Sometimes that credit might exceed the sentence that they would have received if they had just pled guilty or if they had been convicted earlier. And one other problem with speedy trials is that witnesses' memories can often fade a bit. maybe they gave a statement to police, and then now it's a year and a half later, and they're asking him to relate all these details, and they don't know. They don't remember, what color shirt people were wearing, or how dark it was, what was the license plate number, things like that. Witnesses also will disappear or they'll move away. And that can happen, and that can impair a defendant's ability to put on their defense. I think more often witness problems becomes a prosecution problem, but it also can impair a defense. Now, the Supreme Court here's how they define the speedy trial right. They call it an amorphous, slippery, and necessarily relative right, which is really helpful for lower courts as they try to apply the speedy trial test. They did say, though, that there are 4 factors they try to look at. First, they look at the length of the delay. If it's a very short amount of time, in fact, if it's under a year, the courts have said, we don't even ask the question. If a person says, I wasn't given a speedy trial, but I got it within 9 months of the charges being filed, the courts don't even consider the question. It's a threshold. But if you've got a person it's been maybe 5 years or 6 years, 10 years, they look at the length of the delay, and that's one factor they consider. The next thing they look at is the reasons for the delay. Is this because the prosecution was waiting to resolve a trial against a co-defendant so they could use that defendant's testimony against this defendant? Was it meant to punish a person who they thought they actually couldn't convict, and they were just trying to squeeze them to enter a plea deal so they might just get out of custody? Or was it a worldwide pandemic that shut down courts for a year? Those are questions that courts will have to answer. Next is whether the defendant's been asking for a speedy trial, right? Some defendants will, recognizing that the longer time goes by, the more difficult it can be to prosecute cases. They kind of push things off themselves. Maybe they were in custody for another charge, or they're out on bail and they don't care how fast the trial happens. The fourth factor is whether the defendant was prejudiced and the degree to which they were prejudiced. So, for instance, if you have a witness that was a key defense witness and they died, 3 months before the trial was set, but it took 3 years to get to a trial, that would be more prejudicial. So one case that addresses this was the Doggett case. This is a Supreme Court case from the 80s. Mr. Doggett was indicted on drug trafficking charges. For those of you who aren't familiar with the federal system, we have grand juries who essentially the prosecutor presents evidence to them and they make a determination of probable cause. And then at the end of that, they'll produce an indictment. And the indictment authorizes law enforcement to go and get someone and bring them to the court and initiate that criminal charge. We don't use grand juries very much in the state system here in Utah. So the authorities were armed with that indictment. They went to the place where he was living, which was his parents' house. And the parents said, oh, sorry, he left. He went to Colombia, which is really a good place to go in the 80s if you're a drug trafficker, I guess. Definitely an innocent person there. So he's gone. They don't know where he is. About a year later, the lead agent is notified by Panamanian authorities that Doggett has actually been arrested in Panama on drug charges. So he says, hey, can you guys just let us know when you're releasing him and just send him to us? So extradite him to the United States. We'll try him here. Well, the Panamanian authorities didn't. They just released him. And the next year he goes to Colombia. Fast forward. A little bit later that year, he comes back to the United States. I don't know if they didn't have warrants out or what they didn't do, but he cleared customs. So he gets through customs, comes back to the United States, and he apparently gave up his life of crime and got a job, got a home, started a family, and started living his life. Well, in 1988, so it's 8.5 years after the indictment and 6.5 years after he got back to the United States, U.S. Marshal Service they pulled credit reports or something on all these people that had outstanding cases, and they find him. And so they proceed to prosecute him. Well, Doggett says that's not right. It's been 8.5 years since this conduct occurred. And the evidence was that he hadn't been previously informed that he was indicted. Whether that's true or not, we don't know. We just know there was no evidence establishing, yes, he knew that he had been indicted. I imagine his parents would tell him. I would think mine would tell me if the feds came knocking at our door. But he moved to dismiss the charge. He said, my speedy trial rights have been violated. It's been way too long. The trial court held a hearing, and they said, the government was negligent in failing to discover you and inform you about your charges. But where you haven't proven any prejudice at all, we're not gonna, I'm not even gonna entertain the question. So they said, prejudice has to be established. If you can't show that you actually have suffered as a result of this action, tough luck. So I'm gonna have your trial. Supreme Court heard the case and they reversed. Here's some of the reasoning. They disagreed that it was just negligent. They found that it was an egregious persistence in failing to prosecute Doggett. So they said, there were all these opportunities and they just didn't prosecute him. They could have found him earlier. They didn't do it. If they didn't care enough to go and find him, then tough luck, you lose your prosecution. Now, I think if you'd had a person that was, had a warrant out and they were actively tracking him and trying to find him, and he was really good at evading arrest, that would have been different. But they ultimately said, unlike the district court, we're not going to say that the prejudice prong is like the end all. They looked at the other three factors. That was the length of the delay, which was pretty extensive. The reasons for the delay, which was in this case, that they failed to find him and prosecute him, and also he was asserting a speedy trial right as soon as he heard about it. They said that was enough to demonstrate that his speedy trial right was violated. So we know for sure 8.5 years, too long. Now the public trial, and part of that is a speedy public trial, is the text of the Constitution. What does the public trial mean? And why did we do it? So the founders, when they were considering the Bill of Rights, they were aware of historic examples of why we need public trials. So for instance, a lot of people were here from England. The Star Chamber had been there, and that was essentially, a person is dragged into this place. They aren't even necessarily told what they were accused of. They aren't allowed to cross-examine witnesses or know what people said before they came into the room. And then they were convicted in these private, secret courts. In France, it was even worse. The king could just issue these letters de cachet, where he essentially, it's a sealed letter, and he would just speak to the authorities, hey, lock this person up. So if you didn't like someone and you had favor with the king, you could convince the king to just issue this letter and no trial, just lock him up. So the founders didn't like that. So they put in this, we need to have a trial that's open to the public, so there's a bit of transparency. Well, here's a case out of Georgia where Mr. Presley was faced with a drug trafficking charge in a state court. And the court was open to the public generally, but at one point, you've got the prospective jury pool. If you've ever had to serve jury service, they file you in and you fill up a lot of the gallery where the public would be sitting. And the judge in that case said, I don't want the public, who happened to be just one person, Mr. Presley's uncle, who was there to watch the trial. I don't want the public mingling with the jurors because they might hear what the juries are saying to each other. And I'm just going to exclude the public during the voir dire part of it. Well, the evidence that they presented later showed that there was room for him to go sit. They could have arranged the seating so that he wasn't sitting right by the jurors or among the jurors. There was room for him. So he appealed. The Supreme Court takes up the case. And now the court had previously held that the public trial right belongs not only to the defendant, but also to the public. So the public have a right to observe trials independent of the defendant. And they had previously held, and we'll talk about this case in a little bit, that the press had a right to watch jury selection. So if the media has the right to watch jury selection, then surely a defendant's relative who's there should, right? So they said if he's asserting this trial right, it can't be less protective than the right to the public. Let's talk about this case, because this is what they were really pinning that case on. They did reverse. They gave him a new trial because the public was excluded. His uncle was excluded for that process. This case, I think it was out of California. It was a very high profile case. And so the media was very interested in hearing and seeing everything that was occurring. And they wanted to watch the jury selection. This was a capital case. So part of jury selection, and that includes sometimes questions about whether the person supports the death penalty or would never impose a death penalty, things like that. So it's a pretty important part of the process. Now the government in that case said, we really don't want the press here. You got reporters and you got cameras, and the jurors are going to feel this pressure to answer in a way that might seem, I've got the public watching, so I don't want to be honest, and maybe I truly, would I don't like people of a certain race, or maybe I have a sensitive issue that really makes it so I can't be a fair juror, they're going to be suppressing their honest responses. The judge said, okay, I'll let the press watch the general voir dire, kind of where they ask general questions of everyone. Are you all, citizens? Do you all speak English? Those general questions. But when it comes to individual voir dire, I'm going to exclude the media so we can get those honest opinions from people. So for 3 days, they did the general voir dire, but for 6 weeks, they did the individual voir dire. So the media is locked out of the process for 6 weeks. So the jury is selected, they're impaneled, and a reporter says, okay, so now can I get the transcripts at least of the proceeding? Because you can't say that we're going to affect their answers because we're not here. It's a transcript, it's after the fact. Well, defense counsel in this case says, hey, you can't release the transcripts because there was this privacy that jurors had when they were in chambers with the judge and the defense counsel and prosecutor and the defendant. And if they were discussing really personal issues, and we can't just violate that privacy. Prosecutor agrees. They go, look, there was an implied promise at least that they had some confidentiality. So the judge says, no. Trial occurs. There's a conviction. The media says, okay, can you just give us the transcripts now? We just want to review kind of what the process was, what questions you asked, making sure this was a fair trial you gave to this person. Trial court says no. It goes up to the Supreme Court. Supreme Court says, yeah, you're going to release the transcripts. At least redacted transcripts. Closing a trial to the public, they said, is an exceptional thing. It's something that you only do in the face of a compelling governmental interest. If you're prosecuting a mob boss and you want to protect the juror's safety, there's a compelling government interest. We're okay with you closing that the public out for parts of the trial or maybe all the trial. It needs to be narrowly tailored though to serve that interest. So in this case, if the only concern you had was the jurors would not be honest and forthright, or if you're concerned about protecting really sensitive things that they said, the way that you narrowly tailor that is not by saying you can't have any of the transcript. It would be to redact the transcript. So if a juror were to say, I really want to have this held privately, maybe the Supreme Court said that's something that you could consider and you could look at their desires as part of that. But ultimately, the court can just redact any embarrassing or private information from the press. So if someone's, if they detail a crime that's occurred against them, or if they have some deep-seated emotional problem or something, redact it. Just don't release that to the press. And you can explain this person expressed something very personal, very, it was very sensitive, and it would be embarrassing to release it. At that point, you're releasing 99% of the transcript and just redacting the parts that you should. So that's the public trial right. Essentially, the public gets to watch the whole trial unless there's a really, really good reason to close any part of it. Now, a person is entitled to an impartial jury as well. Juries have been around for a really long time, but it's largely an Anglo-American legal tradition. So England does them, we do them, I think Canada still does them, Australia, kind of places that are still kind of English in a lot of ways, but the rest of the world really doesn't. About 90% of the world's jury trials occur here in the US. So we're kind of like the last bastion of jury trials. There are arguments for and against jury trials. Arguments against them are, you've got lay people who don't understand the legal standards. They don't understand, rules of evidence. They don't understand what evidence is better than others. But on the other side, you've got, if you've got a person who's not very trustful of the government, you've got government officials that have arrested you, government officials are prosecuting you, and you've got a government judge. You want a jury that's not made up of people who are in the government. So whether you like it or not, juries are here, I think, to stay for the long run. Now, you're right to not only a jury, but an impartial jury. And there are kind of two ways that you have an impartial jury. First is the way that you form the pool of prospective jurors. And the second is the way that you actually seat a jury that's unbiased. Now, we've kind of taken care of the first matter with this age of automation. If you've ever gotten a jury summons, I think it's randomly selected out of voter registration records and driver's license records, and you come to court on a date. They aren't looking at things like gender or race or anything like that at the point. It's just kind of, you're a citizen, you're called in to do jury duty. Now, seating an actually unbiased jury is also very important. Most commonly, people will challenge the government's use of peremptory challenges as seating a biased jury. So you might have a person who thinks, I'm going to make sure that I have as many women on this jury as possible, because the victim in this case is a woman, and I think that a woman will convict better than a man. That's not allowed. You're not allowed to say that, even if you think it's true. You're not allowed to strike a person on that basis. And over the years, there are many cases of prosecution trying to strike minorities from a jury panel because they felt like, I've got a black defendant, I don't want a black juror because they will never convict a black person. And that's what the Batson case came out of. Generally, that's an equal protection issue. There are other ways that a person could be biased, though, not one of those protected classes. Here is a potential case where that was addressed. So this is a case out of New York where a defendant was being tried for murder, and a potential juror who became one of the jurors, while the trial is ongoing, applies for employment at the DA's office, who is prosecuting the charge. So he wants to be like an investigator with the DA's office. So he submits his application for employment. The prosecuting attorneys learned about this from like a colleague, from a colleague, and they said, "No, we're not going to disclose this. We're going to just tell the people hiring, we're not going to worry about that application until trial's over." Okay, so then there won't be any consideration that could affect things. The DA hears about this after a guilty verdict. So, we've got the trial. I'm sure it was a high profile, big deal, right? It's a murder trial. And then he hears about this little wrinkle, right? That we got a juror who applied to work here and has an open application with us while the case is ongoing. So he says, we got to at least tell the court and defense counsel about it. We're not going to necessarily lose our case, but we got to tell people. So they do. The court holds a hearing. They bring the juror in. They ask them questions. Hey, were you, did this affect your judgment in this case? Did you try and use this to later say like, hey, by the way, I helped convict this guy as a juror. Maybe you can hire me. All that stuff. The court ultimately says, this had no impact on the proceedings or the verdict. I believe him when he says he just considered the case and the facts. So he appeals via habeas proceedings. So he goes to the federal court and says, I want to be released from this murder conviction in my sentence. And the federal district court judge looks at it and he says, I'm going to impute bias. I'm going to say that a person who applies to work at the DA's office who's prosecuting the case, a reasonable person would think this might help my chances of getting a job. At least it would give me a talking point, like in an interview. You'd be like, hey, I know your office really well. I know this prosecutor because I sat in a trial for 4 weeks. Something like that. So the district court grants the habeas relief, which essentially would give him a new trial. So Supreme Court hears this case. The defendant said, we think you should adopt the same rule as this district court judge, and you should impute bias. Say, okay, if there's an issue like this, we're going to assume there's bias, and you're going to have to overcome a presumption of bias as the government. So you can't just say, no evidence that this actually, caused a problem. The Supreme Court actually rejected that. They said due process does not require a new trial every time a juror has been placed in a potentially compromising situation. So they said there will be a case, obviously, where you got a juror, maybe they know a witness, or they're personally familiar with a prosecutor or something, and they didn't disclose that. That's going to be a case that's different. But in this case, it just wasn't enough that we're going to say that the Sixth Amendment was violated. So they reversed that district court and they said habeas relief is denied. So murder conviction stood. Unanimous jury. I didn't know that this was still an issue because I figured everyone had gone to unanimous jury in criminal cases. But apparently, as of last year, there were 2 states who still had, if you had a couple of holdouts, you could still have a guilty verdict in a criminal case. Louisiana and Oregon were the 2 states. All the other states and the federal system all required a unanimous verdict. The Supreme Court last year said, Sixth Amendment applies to this, and you have to have a unanimous jury verdict. So Louisiana and Oregon no longer have that. So there's now a Sixth Amendment right for a unanimous jury that the Supreme Court has upheld. When it comes to confrontation, why do we have confrontation? There's a lot of good reasons for it. You don't want to be convicted based solely on, affidavits and just papers that are filed with the court. Also, it ensures that you have a witness that's sitting in a courtroom and you've got sort of all of the trappings of government authority. it emphasizes to them that it's very important that they be honest and that they give good information. You've got a judge, you've got a bailiff, you've got sort of grandiose halls and things, and it's very clear to people like you need to tell the truth when you're here. A second, and probably most importantly, it's cross-examination. A defendant needs to be able to ask witnesses questions and probe the testimony they've given in case they missed something or in case they were wrong about something. It also allows jurors and judges to assess credibility. Although people are, I guess, studies have shown that we're not particularly great at reading people's body language, we think we are. And so, a juror will watch a testimony and they're like, that person kind of, did you see how they backed off when they were asked that one question? Or they would never make eye contact with anyone. I don't think they were telling the truth. It allows them to assess credibility. So whether it's good or bad, those are the reasons for it. So a case kept probing on this. This was a case out of Maryland where a person was charged with sexually assaulting a 6-year-old child at a kindergarten where he worked. And the prosecution in that case invoked a state statute, and a lot of states have this, where it allowed a child to participate via one-way closed circuit television. So essentially just a camera so people could watch the child, but the child wouldn't see, the galley, wouldn't see the judge, wouldn't be in the courtroom, and most importantly, they wouldn't have to watch the defendant who allegedly assaulted them as they testified. The court permitted that remote testimony, and Craig was convicted of sexually assaulting the child. So he appeals, and he says, this was a violation of my right to confront my accusers. I have a right to face-to-face confrontation. And generally that's true, right? Usually you have the right to face-to-face confrontation. In this case, though, the response from the government was, this is meant to protect a child from being traumatized. Because if you have an abuser and you have a child that's required to testify in front of them and the abuser is there staring at them, the child's going to be either traumatized or they're going to be afraid to testify. And in this case, the witness, the prosecutor, and the defense counsel were in a separate room together, so they were allowed to at least see the child. But the jurors and the judge and the defendant were all in the courtroom. So as I mentioned, the right to confront people and a personal examination is part of the confrontation clause. And that has been interpreted by the Supreme Court as face-to-face confrontation. The main reason for that was it reduces the risk that a witness might maybe wrongfully implicate an innocent person. So there have been cases where you've got a person who identifies, a person out of a photo array or a lineup or something. They say, that's the guy. And then they come to court and then they say, well, how sure are you of that testimony? And they look and they're like, I don't think that's him. It's happened. And so, it's important to have that face-to-face testimony. But the court said, at the same time, we have allowed hearsay. If you've got a person who's dying and they declare, Jim did it or whoever, we allow dying declarations. So this isn't an absolute right. It's subject to some modification. So in this case, they said a person's right to confront an accusatory witness can be denied if there is an important public policy behind it and if reliability is otherwise assured. So did it rise to that level in this case? In this case, the Maryland law required that the person testifying in that person's presence, it would be a traumatic incident. And it would be, the public policy there was to protect children from being traumatized a second time by an abuser. And then aside from that person being in the court, they still had the video camera so you could see the witness testifying so people could assess their credibility. Prosecution and defense counsel were able to gauge reactions. They were in the room with the child. So essentially, other than that, the defendant being allowed to stare down the kid, they didn't really see that much of a detriment. So they upheld the practice, and so that's why I know in Utah at least we have that same rule for child witnesses who are victims of crime. Charges and discovery. So we know that in order to prepare for trial, you need to know what you're accused of doing. That seems like a pretty basic thing, right? If you were summoned to a court and they said you're accused of being a criminal and you had no idea what was going on, you just showed up to court, that would be like a very fair process. You also are entitled to know what evidence do you have against me. That can help you decide whether you plead guilty, whether you go to trial. And the charging documents don't need to be so specific that they had exactly what happened, like point by point, but they at least need to give you notice, like what what you did, what they think you did. And the right to evidence includes not only the evidence that the state wants to introduce at trial, but also evidence that they might have that might be exculpatory. So if they've got an investigation where there's a very clear other suspect and the government hasn't followed up and investigated those leads, you need to give that evidence to the defendant. So the one case that's addressed this is the Youngblood case, where Mr. Youngblood is charged with sexual assault, brandishing a firearm, and also indecent exposure. And there were 3 women who testified at trial that he held them captive at gunpoint and that he sexually assaulted one of the women. And the evidence that was presented at trial was they corroborated each other, and they all agreed with one another. He was convicted, although he claimed that the sexual relations were consensual and that this was kind of made up. It wasn't true. After he was convicted, an investigator was looking into this case. So a defense investigator was looking at it, and he found out that there was a note that was written by 2 of these witnesses, and that it contradicted what they had said at trial and also the other witnesses. It also supported his defense. Basically, the note was mocking him. They were saying like, "Oh, we vandalized this home that you brought them to," and they thanked him for committing the sex act, right? So it was not in line with what they testified to. Now, someone got this and they showed it to a state trooper, like a witness, and he didn't take possession of it. In fact, he said, "You should just destroy that. Just throw that out. I don't want to see that. No one needs to see that." The Youngblood said, "This is a Brady violation. I was entitled to this note so that at least my counsel could cross-examine these witnesses on this note, what they meant, whether it undercut their testimony." Now, the Brady violation, the Brady rule requires that the government turn over exculpatory evidence or even potentially exculpatory evidence to the defense. So as a rule, like, in justice court, it's kind of easy. My case is pretty small. I give them everything. So all the reports, all the photos, everything I've got, body cam, I just give them everything, right? Because I don't want to have it have me being accused of withholding evidence. Well, in this case, the state argued this isn't exculpatory evidence. It's just impeachment evidence. Impeachment evidence doesn't count. It's not exculpatory. Their testimony still stands. The court, the district court in this case, agreed. They said, "You know what? Prosecution didn't know about this. So how can you fault the prosecution for not giving a note that they never had?" They didn't take it into custody. So they didn't hold it against the prosecution. They denied it. The Supreme Court disagreed. They said impeachment evidence is exculpatory evidence if there's a reasonable probability that had the evidence been disclosed to the defense, the result would have been different. So it doesn't have to necessarily be like absolute proof. It's just there's a probability. It's reasonable to think, you know what, this was a closed case. A jury might see this note and say, "I'm going to discount these 2 witnesses," and then that affects the whole balance of the case. And convictions should be reversed on showing that favorable evidence could be taken to put the whole case in a different light. So in this case, they remanded the case to the Supreme Court and said, you need to consider whether this was actually enough to meet that level. So our obligations in law enforcement as prosecutors are, and as investigators in your case, make sure that we have access to all the evidence when we have a case that is sent to us. And if you become aware of evidence that might compromise a witness or something like that, it needs to be disclosed. So you talk to the prosecutor and let them know, "Hey, just so you know, a witness contacted me and they're saying I lied to the police initially." If a prosecutor hears that, we have to disclose that to the defense. We don't like to hear that, and we might think that they're lying now, but we have to disclose it. It just has to be done. Okay, right to counsel is also one of the rights. Hope I'm not taking too much time. Okay, I think we're okay, right? I'm getting close to the end. So right to have an attorney. Every defendant has the right to effective assistance of counsel. And those that don't have counsel, have the means to hire an attorney, have the right to have one paid for by the government. It's a little bit limited. It's only applies in cases where imprisonment is one of the possible outcomes. But effective assistance of counsel means that they will provide reasonable professional assistance. That's what the Supreme Court says. It doesn't mean that they're the best attorney ever. It doesn't mean that they're going to get you off. It might be that you're still convicted, even though you had an incredible attorney who did their very best. Here's a case though, where the attorney may have performed a little bit less than he should have. It's the Padilla case. This is maybe a 10-year-old case. Padilla was a lawful permanent resident, lived here in the United States. He lived here for 40 years, and he even was a veteran. He'd served in the Vietnam War. He was smuggling large amounts of cannabis, though, in his tractor trailer. He was caught doing that, and he was considering pleading guilty to an offer that was made. And his attorney, he asked his attorney, well, is this going to result in me being deported? I'm not a citizen. And the attorney said, oh, don't worry about it. You've been here for 40 years. You're a lawful permanent resident. Not a big deal. Don't worry about it. So he takes the guilty plea. Turns out the attorney was dead wrong. If you read the statute, you are essentially mandatorily going to be deported if you get convicted of the drug trafficking charge that he was convicted of. So Padilla says, I wouldn't have pled guilty. I would have at least gone to trial if my counsel hadn't told me that I wouldn't be deported. Deportation was so important. That was like the most important thing, more important than jail time or fines or any of those things. Well, a lot of courts had drawn a line because you have these ancillary matters. Maybe it's related to, I can't have top secret security clearance to work on base. I get that a lot up here up in Davis County. Or maybe it's, I can't own a firearm, things like that. I'm going to lose my job. These are considered ancillary matters. They're not matters that a defense counsel is required to really advise you on. So a lot of courts had said immigration matters, same thing, right? So defense attorneys aren't immigration attorneys, most of them. So they don't know the law. So you can't expect them to know all the nuances of immigration law. The Supreme Court, though, said, you know what, deportation is going to rise to the level of a penalty about which an attorney can't give bad advice. If you're going to advise them, don't give bad advice. And they said, really, the ability to stay in this country is more important probably than any other consequence. So to say that immigration is just an ancillary and not important issue, not really accurate. So they held in future cases that defense counsel can just tell a client, if they don't know, like they say, I'm not an immigration law attorney. I don't understand how this is going to affect you. If they can just tell their clients, look, this might result in adverse immigration consequences, then they're going to be rendering effective assistance at counsel. And you'll see this a lot in our courts now. Defense counsel will say, I've advised my client, I've tendered the offer, but they need to talk to an immigration attorney to find out what effect this will have on them. But if maybe they're one of those who really think they know immigration law well, or maybe they're one of those that do practice immigration law in addition to criminal defense law, they need to be at least reasonably correct in their assessment. So in the Padilla case, they overturned the conviction, and going forward, if a defense attorney gives bad immigration advice that results in deportation, then a person might be able to get their conviction overturned. As I mentioned before, a lot of you deal with your cases in administrative proceeding before administrative law judge or a hearing officer. All these rights we've been talking about don't apply specifically to the ALJ proceedings. But they would apply to anything that comes out of it. So maybe you've dealt with a person, 4 or 5 times. ALJ is not working; they're not paying their fines. You want to criminally prosecute them. So just be aware that these rights do attach to the defense that you might be proceeding against in a criminal court. So hopefully this has been illuminating for you. I think that is it. So I appreciate your attention. No one interrupted me. Does anyone have any questions or comments now? Didn't expect any. That's why I didn't. I usually like to have audience participation, but Zoom, it doesn't work on Zoom, and jokes don't work either. So I was trying to be more dry today too. Thank you for giving me a chance.
Oh, wait. Sounds like you have a question.
Okay.
Yeah, I have a question. On the facing your accuser, how does that work with the red flag laws then?
What do you mean red flag laws?
The ones where they file a complaint about gun owners go in and remove guns preemptively, and then you get a court hearing later, and you're not allowed to. The order's signed before you're allowed a court hearing.
Okay, so this is like some restricting someone's ability to possess a firearm.
Well, it's actually confiscating the ones they already possess.
Okay. I don't know about that specific procedure, but I would say if it's not a criminal proceeding, like if they're not accused of committing a crime, then the Sixth Amendment doesn't apply. So the confrontation right wouldn't necessarily apply there. There might be like a limited due process right that evidence be they'd be allowed to see the evidence and present witnesses in their behalf. But if they're not being prosecuted for a crime, then confrontation doesn't apply there.
Okay.
Question?
Yeah.
Yeah, I got a question with regards to us on our, when we have to turn over everything, say like a grammar request now, is that something we have to turn over everything we get from the complaint or just our report?
Now, a grammar request is a little bit different because you're not dealing with the constitutional rights that you'd be in a criminal proceeding. So in grandma, you can do things like if you've got a rule that complainants' identities are confidential or something, you can keep those private. Even in a criminal proceeding, I would argue that you can redact the names of the complainants, especially if you're relying solely on evidence gathered by law.
Yeah, that's what I was wondering, because as a rule, we don't release anything until our file or the case is closed. But I just didn't know if that applied or if that was the same type of mandate or mandatory process.
Yeah, so normally you keep your file is protected under grandma until you've got the investigation complete, because you don't want to interfere, have someone interfere with the investigation. But when you're prosecuting a case, though, at that point the file is usually closed, and even if it's not closed at that point, the defendant is entitled to at least as much evidence as you have, so they can prepare a defense.
Okay.
I have a kind of specific question for you, Paul.
Okay.
So here in Saratoga, we run most of our stuff through an administrative court. Like probably most cities that do that, we reserve the right to charge criminally if it rises to that. Where specifically we've opened an administrative proceeding against somebody for a violation, and new evidence is brought in that the person is potentially risen to the level of criminal activity in regards to witnesses that may or may not testify and things like that. Can an administrative hearing be dismissed or closed if they clear the violation but keep the criminal side of it open and prosecute criminally?
Sorry. Yep, most likely. So you're saying, when you say clear the violation, like they fixed it, like they.
Well, yeah. So without going into details, so I personally have opened an administrative proceeding against somebody for a violation here in the city. New evidence has come out that the prosecutor here is looking at for potential criminal charges against this individual for witness tampering.
Okay.
And we would really like that person, the original complainant for this case, to testify, but she's basically says, I'm not going to because this person's intimidated me, threatening legal actions and all kinds of stuff. So the prosecutor is looking at it as potential criminal activity. Can he still then, if they've cleared the violation as far as the administrative court stuff goes, close and dismiss it, but still continue with the criminal proceeding at the same time? That makes sense?
Yeah, I think so. Yeah, I mean, you kind of have two acts here. So, I mean, when it comes to, would you prosecute them for the underlying, the underlying offense? Maybe let's say it's an inoperable vehicle. I'll just use that as an example. So, an inoperable vehicle offense. If that's been adjudicated, it might depend. So if it was adjudicated, but the ALJ found there wasn't enough evidence because people weren't willing to come testify, there's no double jeopardy against multiple civil and criminal. So if they had been acquitted of that in the criminal court, double jeopardy would attach. But where it's an administrative court, especially if he hasn't been found to have violated it, I would say you probably could pursue that in criminal court if your prosecutor wants to. The second act, of course, is witness intimidation, and that could be done, I think, regardless of whether the ALJ proceedings were, resolved with a final judgment or not, because that's an independent criminal act.
Right. Yeah, I was just curious because that's kind of what we're facing right now. Without the prosecutor really wants this witness to testify, but they said several times, I'm not willing to testify, and the prosecutor's not willing to subpoena them out of fear that they just won't be truthful or just won't answer the questions when it comes to the administrative hearing. But I was just curious if he could still pursue potential criminal charges for the witness intimidation or tampering or whatever, without having the underlying root cause of why he brought the criminal charges. Yeah, no, if you've got, I think, I'd have to look at the elements of witness intimidation, but I think even if it's an investigation or if it's seems like there's a word like, presumed or a perceived investigation or proceeding, that if you try to intimidate a witness illegally, then that could be pursued without having a conviction or a finding of guilt to the underlying issue. This one, I had already initiated my notice of violation. I'd already started the procedures for the administrative court, and we were moving forward with a bench trial for that. And then new evidence came to light when I talked to the witness and asked her to testify. And she says, well, I don't want to because this person is threatening legal action and a bunch of other stuff if I do testify after the fact. And the prosecutor said, well, send me whatever you got because I'm going to look at that for potential criminal charges. So for basically intimidating the witness into not testifying against her during the administrative hearing.
Yeah, people think they're really clever, and often they end up in worse trouble.
Hey, Paul?
Yeah.
Can you throw a highlight out there where they've changed most of our stuff now to infractions instead of misdemeanors? Can you kind of highlight the maximum penalties now and the differences because of that?
Yeah, where it's an infraction, that removes the ability for any sort of jail. So, Class B misdemeanors have 6 months of jail, Class C up to 3 months in jail, infractions 0. The only way a person could be jailed in an infraction kind of case would be if the court holds them in contempt, and they would have to basically have enough money to pay the fine, but they're just thumbing their nose at the court. Or if there's some other order from the court that came out of it, like, you got to clean this property up or something like that, they could maybe do a contempt. But even then, most justice court judges are going to be really reluctant to impose jail at all in any sort of infraction case. The maximum fine under Utah law for infractions is $1,000. So you'd be limited to that level. And I imagine most of you don't have that kind of a fine for a single offense.
Awesome. Can you explain to us if anything changed for you when they changed everything down to infractions for how you would prosecute these cases?
It doesn't. A lot of times I would charge even though I could charge it as a B, I often choose to charge things as infractions because I just know my particular judge is not inclined to put people in jail anyway. In Utah, if you've got a Class C, even you have a right to a jury trial. In an infraction, you don't. So that doesn't attach to that infraction level. We didn't go too much into detail today on it, but the jury trial only applies under the federal system if you have up to 6 months of jail or more. But in Utah, it's any misdemeanor, you'd have a right to a jury trial. So a lot of times prosecutors, even though they could charge something as a Class C or a B, they know they're not going to be asking for jail. The judge isn't going to be imposing it. They choose to charge as an infraction. There was a case, I think it was last year, the year before, out of South Salt Lake, actually, where a person was charged with speeding, which is a Class C under the code, but was the prosecutor charged it as an infraction. And the Supreme Court allowed the prosecutor to do that and said, you don't get a jury trial on a speeding ticket. So that's one thing. Another thing is you're not entitled to appointed counsel if there's no possibility of incarceration either. So if you're looking at conserving judicial resources, prosecutors will often charge infractions where they could charge a low-level misdemeanor charge. So I don't know that it really affected me personally because, most of our stuff that we handle here, it's pretty rare actually that we have a case that goes to court. And when it does go there, I usually just charge it as infraction. I know a lot of you aren't in that situation, but that's kind of how it is here in Syracuse right now.
Awesome, thank you.
Anyone else?
Do we have any other questions?
And the room gets quiet.
Okay, thank you, Paul, so much. As always, you give us a lot of great information. As far as Uoka Business, if you guys didn't read the email, we're welcoming Greg Horsepool as our secretary. So there he's there, if you can see him on the screen.
Hi.
Yeah, we are still looking for a training officer. Jim has had more responsibilities put upon him, so he can't devote the time. So if anyone's interested in helping the board, we'd appreciate it. Send an email to a board member. And that'll be about it. We'll see you next month.
Thank you, Paul.
Thanks, Paul.
Thanks, Paul.
Thank you.
Thank you,
Thank you.
guys.
Everything's going well for you down there.